Hey everyone, welcome to the Bold Lawyers Show. I'm your host, JD Hoovener, owner and founder and patent attorney here at Bold Patents Law Firm. This show is for you, the attorney, the perhaps law student looking to hang your own shingle someday. This is the Bold Lawyers Show. We're here interviewing attorneys, and some of them will be founders of their own firms or in-house at other firms, hearing their story as entrepreneurs, as part of their legacy as they help clients and inventors. We'll also be, we got two guests on today, special guests that are in-house here at Patents. It's my pleasure to have them on our show. We'll bring them on in just a few minutes. We've got our very own Michael Dodd, who's a senior patent attorney who does all of the initial consultations for inventors here at the firm and does oversee a lot of the legal work as well. And then Matt Kulseth, who you know well, he's in-house here at Bold, and we're really happy to have him. He does all of our initial trademark consultations. So let's bring them both on. Welcome, Michael. Welcome, Matt.
What's up, fellers?
I'm actually going to be interviewing you today, Matt. This is going to be so much fun.
Cool.
Appreciate you cleaning up a little bit. Again, you've been leveling up your game, callers and everything.
I was at a wedding this last weekend, so
Oh, yeah.
God forbid I actually shave today.
Yeah, I'm going for the super slick back. I mean, you can see I found the moose today.
You look fast.
My wife doesn't like it. She's like, dude, that looks a little too like greasy, kind of old school Italian-y. And I'm like, all right. So anyway, but here it is, because this is what I look like coming out of the shower. Michael, it's so good to have you on our show. How you doing?
Thanks for having me. Good. How are you guys?
I'm good, really good. So this will be fun. We are live across Facebook, LinkedIn, and YouTube. This program, this podcast, and video is for lawyers everywhere and anywhere that are curious about what it's like to run your own law firm, run a law firm, be a part of a firm. And this is sort of a special here. Normally we do interviews of other law firm owners. But here today, we have an opportunity to go in-house at Bold because, hey, I run this show. Why not? And I wanted to set it up so we have the chance to get to know you, Michael. You're usually behind the scenes working with inventors, most of them first-time inventors. Some have been at it for a while, and you do the initial consults with them. And you've been doing that now for us for quite a while. I'd love to kind of start with you, Michael, if you don't mind. And Matt, you can jump in a bit, but we'll kind of interview Michael. Why don't you give us your background? Give us a story on how you got started with the law and how you found Bold.
Okay. So I started out my college career getting an electrical engineering degree, graduated with that in 1991. One of my last job right before law school was working at the Knoxville, Tennessee Police Department. I was doing their computers, and I kind of got interested in the law through hanging out with cops all day long. Thought I joined the reserve unit. I was a reserve police officer for about 18 months. We worked the UT football game.
I did not know that, Michael. That's super cool, man.
Yeah, I had my own corner where I directed traffic after all the University of Tennessee football games for about
you did.
Then I got to law school. Well, so I thought I wanted to do criminal law. It took doing one criminal clinic till I realized I did not ever want to do that. And then my dad had worked in the patent field. He's a patent agent. He has a PhD in EE. And so he's like, you already have the technical degree. You should look into patents. Cool. So switched over to that. Actually took and passed the patent bar while I was still in law school. So I kind of had that out of the way. Then I graduated in 2000, been doing patent prosecution kind of in one way or another ever since then. So.
Love it. For some of those maybe out there, attorneys who don't know what patent prosecution is, what's the difference? Does that mean you're in court, out of court?
That actually means I'm not in court and never have to go to court.
Right.
So, yeah, it just means it's just basically driving the process at the patent office for a patent application with the patent examiner. So.
Cool. You mind sharing, what kind of firms you've been with over the years and how you ended up finding Bold?
Yeah. So I started out at a medium-size intellectual property, I guess you would say boutique. I don't know what size makes it not a boutique, but at the time it was about 45 attorneys. Mm-hmm. And we had some pretty large clients, large software companies that I did a lot of work for starting out as an associate. That's what I kind of cut my teeth on. Went through the whole law firm thing from associate to partner, was there for a total of 12 years, left there in 2012. And I had my own firm, just a solo firm, just me, from about 2012 to 2018. Was in-house for a little bit of a stint with the startup that didn't do it as inside patent attorney, essentially. That company had some financial issues, unrelated to patents, and kind of went down, essentially went away, and it's in the incarnation it was in. And then after that, that's, I was looking around, and that's how I found Bold. And I've been with Bold for, it was 2 years in May. So almost 2.5 years.
Yeah. Awesome. And you've kind of found a sweet spot, where it's like, hey, you don't necessarily want to be grinding away, in year 20 of doing patent work necessarily. You're doing consultations. So what does that entail? Maybe for someone who's not familiar with that, what does that mean? And how is that, how are you able to speak with clients?
Right. Well, I think it's one of the more unusual things about Bold. And actually the reason that I was drawn to the position was I get on the phone or a video call with a prospective inventor, most of which you've never been through the process before. Might be a little bit nervous. And, we sit down, I have them kind of tell me about their invention. I'll run them through the patent process, which usually is pretty detailed because most of them have not had any experience before. But we'll go through the different types of patent applications. What's the content of a patent application? How's a patent application get created up through filing? And then I think the more interesting thing for some of them is what happens at the patent office. Well, there's some resources out there on how to draft your own patent application, I think, more than how do you deal with the patent examiner at the patent office. That's really there's a pretty big curtain across that. So I'll try to pull that back for them as well and just talk them through that and what they're looking at, realistic. What are you looking at end to end, time wise? What kind of financial resources are you gonna have to devote to this, and just try to really educate them and make them feel comfortable. So when they make a decision, they feel like they're informed.
Love it. What would you say, like, the top reasons that they're worried? Like, what are they coming in like scared about or wanting to know the most?
A lot of people have, the financial considerations are a big deal for a lot of people. I think it's just a huge unknown quantity, right? I mean, even if it goes smooth, you're looking at, let's say 2.5 years in most cases to work something through the patent office. And it's a big investment. And then they want to know, I think too, is whoever they're talking to, which is me to start out, or whoever at Bold, is that person going to be there with them through the process? They're like, are we going to write this patent application? I'm never going to hear from this person again. And I know that's a concern for a lot of people, because I often talk to people that have started out somewhere else and have gotten, pricing information that's actually pretty unrealistic to do patent applications. They've gotten, felt like other attorneys have dropped the ball on them. And so we've got to kind of work through some of those things too sometimes. Right.
Well, what would you say to someone who's got an invention? Maybe they're kind of thinking about doing it on their own or hiring a firm, and they're kind of hesitating on whether to have a consultation. They're worried about confidentiality. What would you say to someone like that?
Confidentiality, I try to tell everyone, is not a concern. Most states, bar associations have ethical rules that we have to comply with as attorneys, which apply to prospective clients as well. If we don't uphold those ethical rules, I mean, they can file a bar complaint up to, potentially getting disbarred. I think all of us like our jobs, and, we don't want that to happen. So there's some concerns there. What was the other part of the question?
Just, people that are out there that have inventions and they're wondering, whether to hire a firm or not,
I think if you've never done it before, a firm's definitely the way to go. And I'm going to say this from experience, because doing these consults, and I do somewhere between I don't know, 12 to 20 of them a week. So I have a wide variety of people that I talk to, people that are just starting out, people that have not talked to any attorneys yet, to people that are trying out other firms, to people that tried to draft their own provisional or their own non-provisional. Now they're in a little bit of a jam. If they've done a non-provisional, they're getting a rejection. They don't know what to do. And so, then we come in and have to try to figure that out. And one thing I will say, a lot of times it can be more expensive to fix what's going wrong than if you had started out on a good path to start with.
Yeah.
And then the other thing I will say there too, there's a variety of quality law firms, Bold being one of them, that I think are reasonably but realistically priced to help out small and solo inventors. If a deal seems too good to be true with respect to the cost for patent drafting, it oftentimes is. And I've seen that in my experience with talking to so many people.
Love it. Last question here. So if I'm going to invest my time and money, speaking with you on a consultation, what am I going to come out of that with? What answers? What am I going to take away?
You're going to get an indication. If you're doing it with me, you're going to get an indication if in my professional opinion, your invention is detailed enough to potentially move to the next stage,
Okay.
which often is going to be a patentability search. And if it's not, we can talk about that. How can you detail some of those things out? And then you're going to get a really, really good education on the end-to-end process from patent drafting. How's a patent application get created? What are the different types of patent applications between design and utility, and then provisional and non-provisional within the utility space? What's going to happen to you most likely at the patent office of the patent examiner? And even as detailed as what is a patent examiner doing? What are the requirements they're looking at in a set of claims to see if they meet all the requirements to turn into a patent? That's really what people want to know. And I feel like if I get off and they're educated and it comes around, hey, do I want to do this or not? They're making a decision based on the facts that they're going to be looking at on how to go forward.
Awesome. Thank you, Michael. Yeah, I'll say just from, anecdotal, looking back at some of the numbers and stuff, we've got a virtual zero in terms of people seeking a refund. We've had it, people speak with you, Michael, and even though they don't move forward, they're still getting a ton of value, right? They still learned a lot. And maybe the decision was not to file or whatever it is. They're able to get value from that initial consult.
Yeah, and I'll just add, I mean, I like it. It is a unique position. I get to meet with inventors and learn about their invention and do that 12, 15, 20 times a week because I had gotten to a point where I was, doing the same thing for 20 years. I was looking for a little bit different take. I didn't want to not be a patent attorney, but I also didn't want to grind patent applications out all day long because I'd done that.
Yeah.
So it's a great position, and hopefully people do feel educated no matter what they decide their next step is.
Awesome. Well, thanks a lot. We'll have you stay on here. We're going to pick on Matt here. Matt, you still with us here?
Sweet. Yeah, no, I am. That was really interesting. Basically, like all the questions you asked me, just same answer with
Hey, your family in the background. They're famous. Someone's walking right behind you.
Yeah.
Get
Get ready.
Right.
No, that was great.
On the windows too, right?
Thanks for kind of walking us through your process. I mean, it's I talk to a lot of the same clients, right? We have a lot of overlapping trademark patent clients, and they always rave about talking with you and kind of that education piece that you spoke about.
Oh, thank you.
Yeah.
Matt, give us your story. Let's have it. Give us a little bit of your background, educational, and and then we'll
born and raised here in Minnesota, and went to school out east at the University of Richmond. Came back for law school at William Mitchell, which is now Mitchell Hamlin School of Law here in the Twin Cities, Minnesota. And I was a poli-sci major, so I always wanted to go to law school, right? I was like a political science leadership studies major, and I was like, I'm going to law school. I don't know why I'm going to go to law school, but I'm going to go to law school because that's what people tell me I should do. So,
did you know right away? I mean, did you know when you were an undergrad? You had that?
Yeah, the plan was always to go to law school. I thought I would probably get more. I thought I would probably end up in the government or the legislature here in the state. That's kind of where I was probably going to go.
Did you
But
have
obviously,
any family, father, grandfather?
no, I had a really cool mentor who was a nonprofit lobbyist. And I followed him around one summer in law school and really liked what he did. He did a lot of lobbying on behalf of, poor people here in the Twin Cities in Minnesota. And thought, hey, that's a pretty cool job. It, pays pretty well. And, you get to do good work and, you get to talk to people all day, which is what I love to do anyway. So I was like, oh, I can do that.
Man, when I got done with undergrad, I was so done with school. I never wanted to go back again. I don't know how you could have been like, I want 3 more years.
Well, I took a year off between undergrad and law school. I went to Africa for like 6 months with my then girlfriend, now wife, and traveled and worked there.
Nice.
And I also managed to go to Burning Man between law school and undergrad. So
we need to flash a picture of like Matt in 2004.
Oh yeah, I mean, thank God that like selfie cameras were like just becoming a thing back then, right? So,
right. That's awesome. Okay,
yeah.
So yeah.
Went to law school. It was the recession. I was there 2008, kind of when everything fell to pieces, and I remember sitting in a class, and my teacher professor looked around the room, and he's like, "Your job's gone, your job's gone, and your job's gone. So what are you gonna do after law school?" And I fell into trademark law, and really liked the legal aspect of it. The case law was interesting to me. It seemed like a backdoor into patent law and intellectual property in general, which I found very interesting. And then, second, I really enjoyed my professor. We had like a really great relationship. And so it's like, I'm going all in on intellectual property, specifically trademarks. And when I come out of law school, I'm going to be able to hang my own shingle. I'm going to be able to do patent prosecution, patent application work. Yeah. And life will be great. So that's basically what I did. Turns out it's a lot more work to hang your own shingle than you think it is. And so I ended up doing like document review, which is a terrible, terrible job that no attorney should necessarily aspire to. I did that for a couple of years at night from like 4:30 in the morning till 1:30 in the morning.
Well, then you did what from 4:30 to 1:30?
Document review.
Oh my gosh.
I did doc review right out of law school while I started my own practice.
Okay, so you had something to pay the bills.
I had something to pay the bills.
Okay, there you go.
So that's what I did. I just ground basically for 2 years until I had a big enough book of business where I could more or less do the trademark work full time. And, obviously a lot of that time was spent, marketing and trying to grow the practice as much as I can. And then, you and I are big networkers, JD. And so that's how we met. I mean, I don't even know how long ago, maybe 6-7 years ago at this point.
Yeah.
And that relationship, has obviously borne fruit. And, I've continued to work with you and Michael and the rest of the crew at Bold IP for, I don't know, 4 or 5 years now, something like that.
Yeah, it's been a while.
Yeah.
Let's do the same kind of question stuff. I mean, a lot of people may be watching this and have questions, and they want to know what an initial consult is.
Yeah.
Talk with Dallas first. Dallas is our client service rep advisor,
sure.
And then they get the opportunity to meet with you if they're a good fit. What do they expect? What are they going to get with a consultation with Matt Kulseth?
Yeah, much like Michael. On the trademark side, my job really is to build a relationship, build rapport with a potential client, make them feel comfortable that what they say with me stays with me. 2, it's to educate. That's a big piece of what most attorneys who do transactional law do, is educate clients about the risks or the benefits associated with any sort of legal maneuver. During our consultation, I'm going to explain the trademark process, the federal trademark process. Generally speaking, we're going to do, if the client is interested in a trademark application, I'm going to conduct a knockout search prior to the call if I have the information, or I'll do a knockout search on the call with the client. And that knockout search is just looking for red flags that would say, hey, like we have a major problem here. We should not even consider moving forward with a search report or legal opinion. Conversely, sometimes we do those knockout search and things look so good and the client's so confident that their trademark is unique that we can recommend that the client doesn't even need a full search report and legal opinion to move forward with the application work. So it really is kind of a strategy meeting where I'm getting to know the client, I'm educating them, I'm learning about kind of what they do and how they do it. And then, translating that into what an application or what a legal, opinion might look like if we were to move forward with the client as a.
Wow. So you get things moving. You actually do a little bit of a search, and they get a feel for whether they can move forward and protect their market.
Right. Because even if you have information as an attorney prior to going into a client consultation, at the end of the day, you really don't know what the client is interested in protecting or where they make their money, which is, obviously what you want to protect from a trademark perspective, or where they, are going, long term with the business. So want to educate, want to get a good feel, want to have a good plan coming out of that meeting, so that when I send them back to Dallas, he's going to get them signed up for, full search report, legal opinion, multiple classes, or single application with no trademark search report or legal opinion. We want a really good strategy coming out of that meeting.
What would you say are kind of the top 1, 2, or 3 things that a first time, filer says, "Oh, wow, I had no idea," or now I get it, right? What are the
Right. Yeah. I think there's a lot of folks, at least on the trademark side, who are confused about kind of like what it is they do. And that sounds funny, right? But my job as a trademark attorney is to take what a client does, whether that's a service or a product, and translate that into one of these 45 different classes of goods and services that the United States Patent Trademark Office uses.
Kind of fit it in the bucket. Explain the buckets first.
Yeah, so there are, like I said, 45 classes of goods and services. The first 35 or first 34 are going to be all service or product categories, and then classes 35 through 45 are services. And everything that we do, buy, sell, rent, whatever, falls into one of these 45 classes. A lot of times clients are going to be in multiple classes. They might be an apparel manufacturer, but they also sell the apparel. Maybe they also manufacture jewelry. So they're going to fall into multiple classes depending on the trademark strategy. And so it's my job, especially with clients who have really unique services or really unique products, is to translate that into a category at the USPTO that we can apply in, and then search that category and associated categories for issues like descriptiveness, likelihood of confusion, or geographic descriptiveness issues, surnames. Basically go through a whole checklist of potential pitfalls to the registration.
Got it. What would you say kind of adds the complexity, in terms of like where you're going to need to do a more deeper dive search? When does that?
Yeah. So if a client is going to come to the firm, bring with them a fairly descriptive trademark, something that's not very unique, right? That's going to definitely cause us some potential issues. So we're going to want to do a full search report, legal opinion, so that we can have a proper strategy to get around any expected issues during the trademark prosecution process.
Cool.
So that's a big one. Clients are always interested in, if they're starting businesses, do I have the LLC? Do I name the LLC the same thing as the trademark? Or, I sell T-shirts, but am I also a service company? So there's a lot to kind of flesh out for a lot of clients. And most clients who have a product that they sell think of themselves as a product company. And my job is to really say, hey, you are a product company, but you're also a service company, because you sell it, you distribute it, you do customer service, you take wholesale orders, right? You have an online store. So we need to kind of look at the whole picture for the client as opposed to just the one category at the USPTO.
Love it. Well, thank you, Matt, for walking us through that. Good stuff. Yeah. I know it does come up once in a while. I know they'll come in with an invention, Michael, right? And you're talking with them, and all of a sudden light bulb goes off. Maybe they need to talk to Matt too. How often would you say that comes up?
When they get to me, a lot of times Dallas catches that first.
Oh yeah.
Sometimes when they get to me though, I'd say 15% of the time, maybe we'll be talking about the invention, and then they'll be like, we're going to call it whatever name.
You're like, no.
And I'm like, okay, well, that's not me, but we'll go with that. And, so.
Right.
Yeah. It's less likely on my side that I get to send stuff to Michael, unfortunately, because we are a patent firm, right? That first and foremost, Bold IP is a patent law firm, right? And so clients come here for patents, and they might stay for trademarks, right? But generally speaking, I think Michael's 100% right. Dallas does a great job of kind of sorting out the client's intentions.
Cool. I'm kind of curious, what are some other, IP areas or maybe even non-IP legal issues that come up sometimes in these consults? And you guys go through a lot of these, and you give me some fun kind of out of the box idea.
Naked licensing issues. That's a big one. A lot of times clients will come to me and they might have a trademark registration already, but it's owned by them as an individual, and they're running everything through an LLC, and there's no licensing agreement between, them as the individual trademark holder and the LLC. And there's a lot of little business law issues that come up during the trademark, process.
Got it.
Michael, what about you? What you got?
I think one of the bigger ones on the patent side is they haven't even filed a patent application yet, and they want to know if they can license their technology.
Yeah.
And I have to explain to them that, until you have some issued claims, it can be a pretty tough and unlikely thing to happen.
Right.
And I think a lot of people don't know that. They get, some of these other online places actually, patenting is actually their ancillary activity because they're trying to get people to license and monetize stuff. And then they don't know why it's not working. And well, it's because you have no actual protection. Right. And so nobody has any legal motivation to give you money for any units of your product because you actually have no protection. So I think that's kind of giving people a reality check on that is a thing that I have to do sometimes. So,
yeah. Do people ever ask you, and I think I remember this, hey, what do you think of my idea? I mean, just sort of, hey, tell me, what's your gut?
Yeah. Okay. That's actually a pretty big one. And I think the thing I would say there is I get a lot of people and they ask me, do you think I can get a patent on this?
Yeah.
And what I tell them is that is not the right way to ask the question. The actual question you should be asking is, what are my chances of getting claims of reasonable breadth that would actually give me some leverage in the marketplace, right? Because I can get someone a patent on anything, but if a claim has 26 limitations, the chance of someone infringing those claims is virtually nil. And so the patent holder has a worthless piece of paper.
There you go.
Right. And that's a thing I think people don't realize. Just getting a patent itself as an act doesn't really do anything.
Yeah. Love that. I mean, Matt, you probably get people asking, hey, I need to patent my logo, or I need to trademark.
Yeah, people get that confused a lot. And so I try to educate copyright, trademark, patent, trade secret, all in like 30 seconds, right? Kind of what each of them is. One thing that I do, see pretty often is we'll have clients come through the door and they'll want to know if their brand is a good brand. They want my opinion, right? They're like, you see brands, you know what a good brand is, or bad brand. If the client's already in the marketplace with a brand, I kind of dodge that question to be totally honest, right? Because I don't need, to tell them that the brand's, not great from a consumer standpoint. If we can still register it, that's kind of beside the point. But I do take the job of like counseling a client very seriously when it comes to choosing a new brand, right? When they have the opportunity to do so, and they're looking for that like great, suggestive, sticky brand that consumers are going to recognize and remember. Like that's my opportunity to kind of tell them like, hey, like I don't like this brand from this reason, or I've seen other clients do something similar and have more success doing something different. I do try to kind of steer clients in a way that they can both register the brand and also that it's gonna feel like a real brand when they go to market with it. Because we can't all be good at everything. I'm certainly not all good at everything. So it's good to have feedback from folks who should know better than you.
Love that. Yeah. Well, we are at the end of our half hour. Again, thank you, Michael, and thank you, Matt, for being on and sharing us with the audience here and with me, kind of what it's like behind the scenes at the initial consultation. If you guys have any questions and want to get hold of us, please get hold of us on our website, boldip.com. You can see their profiles for Michael and Matt. And if you're a first-time viewer, I'll give you a link after we send this live out to schedule a free 20-minute discovery call. And that'll be with Dallas Richardson. You may have heard his name come up in this broadcast. He'll let you know if you're a good fit, honestly. And if gathering information and we make sure things are good, we'll line you up to speak with either Michael or Matt on a consultation. So on behalf of Bold, Michael and Matt, wish you guys the rest of your day. We'll be here next week at 2:30. Go big, go bold.
See you, fellas.